Welcome back to Sunrise 80. Well, yes, as you've seen there, Mr. Mama Chukwume, a senior advocate of Nigeria, lead counsel to the APM in this presidential case that will be concluded hopefully today. So he joins us here in the studios. He's also a former Attorney General and Commissioner for Justice for Imo State. Good morning, and thank you for coming in today, sir.
Thank you very much for having me.
Well, what an interesting time they were in. So a lot of focus on the Supreme Court today, rightly so, to hear what will come forth from this part of the case that you were in, which eventually was struck out. But reading through what went on at that Supreme Court where, you know, you had presented your case, and curiously, part of the quote here is that the judges were asking, quote, what will you gain if you win this appeal? There are other appeals that are asking for something substantial. There's nothing to gain but to give us work to do. You're not asking us to put your candidates there as president. So this, we understand, was before you then withdrew your appeal and then it was struck out. Is this what transpired?
I think with respect, I'm not here to question the Supreme Court. The Constitution has made the court, whatever the court comes as a decision, we abide by that. But then, comments can still be made. One, there is always this right that your APM didn't go there without an aim. APM went to Supreme Court for purposes of determining what is the provision of the Constitution that created it. If there is no Constitution, APM couldn't have been created. And the APM has a duty to say what has transpired in the election he participated was wrong. Because if you look at all the petitions that were filed, no one went on that narrow issue of whether the presidential candidate, APC, and its vice presidential candidate were validly nominated for that election. In the first place, what did the law say about questioning election? If you look at section 239(1), it said the Court of Appeal has exclusive jurisdiction to determine if somebody is validly elected. The word is elected. The qualifying word is validly elected. So the question now was, the person that was declared elected, was he validly elected? And that brings now to the narrow compass of APM issue. That for you to be qualified as provided by the law under section 142 of the Constitution of the Federal Republic of Nigeria, that says you cannot go into a presidential election. This is not House of Assembly. This is not House of Representatives. This is not Senate. We are talking of presidential. The presidential, just like that of the governor, a governor cannot go into election without a deputy. And the presidential candidate cannot go into election without a vice president. And the way and manner these candidates are nominated are properly stipulated. The question now is, by the provision of section 142, was that a valid presidential candidate? You have to look at this from the provision of section 33 of the Electoral Act. That said, once you have nominated a candidate, once a party has sponsored a candidate under section 29, you can't make a change except by death, except withdrawal. Did Masri not withdraw?
So, from my understanding, in terms of what's out there, they are ruled that double nomination question raised by the APM, which you represented, was a pre-election matter. and ought to have been ventilated at the Federal High Court. And he said that the double nomination of a candidate by a political party was an internal affair of the party.
That decision made by our Supreme Court in PDP and INEC. Beautiful judgment. Very beautiful judgment. It considered section 29(5). It considered section 84(14). It considered section 285(14) and all the rest of them of the Constitution. Question now is this. When we went to the Supreme Court, we raised any issue on it. Did we? You can only make appeal by your notice of appeal. You can only make your appeal by your grounds of appeal. You can only make your appeal by your brief of argument. If you go to the 10 grounds of appeal we filed, supported by 56 particulars of error, none of them raised the issue of double nomination. I looked at yes, I read the judgment of the Court of Appeal. And then I saw that we can make a good case on double nomination. So I avoided it like a leper. We never mentioned anything about double nomination.
How did it come across to them then?
So I'm just stating what I have in my, which is on a record. It's on record. I didn't mention anything double nomination because I found it not necessary. It will not help my case. The only single thing we went to Supreme Court was that a proper vice presidential candidate? And if there was no proper presidential candidate, under Section 142,
okay.
That's all we went for.
Okay, you say that this doesn't border on double nomination.
Our appeal.
Your appeal.
Appeal never has anything to do
That's
with
the appeal at the Supreme Court?
Yes.
Okay.
The case presented at the Court of Appeal has a mixture of that. But then it is for me to sip the one that we carried a day. So we avoided double nomination. That was canvassed at the Court of Appeal. We avoided it and we went with the one we believe in. So the one we believe in didn't include double nomination.
We'll come to that shortly in terms of what exactly your appeal at the Supreme Court contained. Excuse me. But just in passing, I remember on that day, on Monday, we had a lawyer, senior advocate in the studio, and I was just saying in passing that who stands to benefit from APM's case, really? I was just wondering, you know, in my mind, who stands to benefit? Assuming your case had gone through with the Supreme Court and it wasn't struck out, and the Supreme Court found merit with going through with what it is that you had presented before them, who stands to benefit should you have, you know, gotten victory at the Supreme Court?
A lot stands to benefit. APM stands to benefit.
How?
One, if an elected president is nullified, the election is nullified, what comes up? What comes up?
A re-election?
A re-election. At that stage, would the APM be sleeping? APM will gather up its asses. APM knew where he was going. APM knew that if he does this work for Nigerians, if he's able to pull this through, its influence, its importance will be realized. And it will gather a lot of momentum in fellowship. And in the next election that will be coming up, is going to show Nigerians will embrace APM because it has been a pointer to a success. That's one. Secondly, apart from its personal benefit, what about the Nigerian public? What about the Nigerian public? We must not live for ourselves alone. We must always, sometimes, work for the public as well. But most importantly, APM has channeled this machinery to benefit from this. The way it's going to go about the political maneuvering is left to it. But first and foremost, he couldn't have been pushing for this appeal. He hadn't have so zealously pushed for it if there is no political aim it has. And he did not say, after the declare election and everybody go home. I mean, so remove him and everybody go home. No.
I wish I had the results, the final results of the 2023 elections, general elections, which are now being contested before me. But I do know that APM did not show anywhere in the first 5 or
I want to let you
thereabout.
know. I want to let you know that the Nigerian electorate are now very sensitive. If APM has succeeded in its appeal, you see the way things were done. Even if it came 10th, yes, they will now know it has us.
But if the APM has succeeded, yes. So what? Because part of the narrative too, the question was, because it was, okay, look, then there'll be fresh elections?
Fresh elections.
So the APM was essentially pushing for fresh elections.
Yes.
Meanwhile, there were other people, I mean, there are other people before the Supreme Court who say, look, these elections were not properly conducted. If you look at our cases, we ought to have been declared winners. But what you are pushing for is a total reconduct of these elections. Is that really in the favor of Nigerians? Is that really a scenario that we can afford as we speak?
You see, it's for you to make a prayer to the court. It's for the court to take whatever is the necessary step to be taken. It's not every prayer you make is granted. But the most important thing is something has been done.
Okay. So let me go, because the statement which Chamberlain read out was quite instructive, because it does appear that what the Supreme Court was saying is that what you wanted us to do was an academic exercise. Was that what you... Was that
I'm just saying this is what APM has in mind. I'm not to contradict the Supreme Court.
Okay.
But this is what APM has in mind. And if it happened done, of course, what will come out of it, and most importantly, there will be a decision. That decision will not be only beneficial to APM. It will be beneficial to know, can a presidential candidate change a running mate not within the confine of the 14 days stipulated by Section 33 of the Electoral Act? Can he do that?
Okay.
If that decision is made, is it not for the benefit of the generation to come?
Okay. But that particular part, when the court also said, yes, it may be in the law, but it is not an all-comers affair. It's an internal affair of a political party.
No.
Wasn't that part of what the court also said at the time?
Yes, beautiful. That has to do with a pre-election matter. Now, if you look at Section 229(5), it talks about this issue. But there's something is said. Aspirant.
Candidate.
Aspirant. You must be an aspirant in order to come and contest what happened in an internal affairs of the party. You must be an aspirant.
An aspirant, whether you're in the same party or not?
No. You must be in that party.
Okay.
Good. The same thing applies. That's what, if you look at Section 84(14), it said, notwithstanding anything in the provision of the Electoral Act, if an aspirant feels somehow, it goes to Federal High Court. The question now, the same thing applies to 285(14). The question now is, what about the provision of Section 131C of the Constitution?
131C. Okay.
That said, for you to be qualified to contest election, you must be properly nominated by, sponsored by a political party. Then you now look at section 142 that says this is how a presidential candidate will come up. So the question now is this: are we, if we are to talk about validly elected, what are the content of validly elected if you will not have the locus to question, though you are not an aspirant, because you have participated in the election, APM has participated in the election, haven't participated, and then contesting against somebody that is returned, does he not have locus to contest that, to file a petition? Does he not?
But the court, the court read out.
So the two are, with respect.
Yeah, I understand.
The two. This one is for when you are talking of pre-election. We're not coming under the auspices of pre-election. We are coming under the constitutional provision that said once somebody is elected, you have rights. Who has the right to contest whether that election was validly made? That return was validly made.
In part of the narrative out there too, the court also read out, they went on to read out the constitutional requirements for qualification to run for president. They listed it. Person must be a citizen of Nigeria by birth, above 40 years, and read out all of the other ones. And then they said, look, we don't have any powers to create additional grounds to disqualify any candidate standing for an election. But that's the impression they have of this particular matter, that point.
Yes, and that's the stand of the Court of Appeal. That's the stand. And that's why we raised appeal. That's what the Court of Appeal said. Beautiful. We respect it. And because we respect it, we now wanted the Supreme Court to find out whether the provision of Section 142 is just there, idle, lying there, and of no use. Because the law is that the Constitution must be interpreted wholesomely. Wholesomely. The question is this: if the Section 142 of the Constitution is saying, makes it mandatory that you must have a valid vice presidential candidate.
Okay, just for the benefit of our viewers, sorry to interrupt you, I'm just going to read through Section 142, and it speaks to the nomination and election of a vice president.
Yeah.
In any election, I'm reading now, to which the foregoing provisions of this part of this chapter relate, a candidate for an election to the office of president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running for the office of president, who is to occupy the office of vice president, and that candidate shall be deemed to have been duly elected to the office of vice president if the candidate for an election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions aforesaid. The provisions of this chapter relating to qualification for election, tenure of office, disqualification, declaration of assets and liabilities, and oaths of president shall apply in relation to the office of vice president, as if in references to president were references to vice president. I'm reading this,
Yes.
and I'm not saying precisely what the APM was contesting.
Good. That section refers to vice president as a candidate in 3 places. Candidate. So it means that the vice presidential candidate is a candidate. Then you go to Section 33 of the Electoral Act that says once a party has submitted a list to INEC, you can't change that candidate unless by death or withdrawal. So automatically, a vice presidential candidate is a candidate read in Section 33 of the Electoral Act. So if there is any change, what happens? Having become a candidate, and if you look at Section 152 of the Electoral Act, which defines a candidate, it also includes the vice presidential.
Okay.
So if you are within the purview of Section 33, which said you cannot change except by withdrawal or death, what Masri did as the fifth respondent was he not to withdraw? Was he not a candidate, having been submitted by APC under Section 29? Section 29 says you must bring us a list. Once you bring a list, they have crystallized as a candidate. All
right.
So what we are saying is
that he did not withdraw properly?
The Masri withdrew, but the 14 days for substitution was not done.
Okay.
In other words, the APC had no candidate.
Yeah, because it was submitted 6 days after the 14 days.
Okay, right. So this is interesting that you have this book here.
No.
I'm very interested into as to what this book is meant for, because you've been quoting the Constitution and the Electoral Act, and I know that's not the Constitution and that's not the Electoral Act.
It looks like the Book of Life, but just hold up. We have to go to court.
So your name is there.
Okay, our correspondent Shola Shoyele, she's at the court now, and
I
think we need to ask her. Let's find out what's going on, because the news that was filtering in was that there was all kinds of checks and actions. People were being turned back. Hello, Shola. What's going on now? Could you just give us the current situation at the moment? Okay, I think that we'll sort that out. So, all right, let's get to the Book of Life. You wanted to ask a question about this book?
Yes. So you've made the point.
It's not 1999 from what we see.
I mean, just take a look at the edges. It will tell you when that book was published. What book is that, sir? And precisely what point were you going to hope to make from it?
This is a law report that is very close to my chest. It was published in 1866. 1866.
Before any of us here were born.
1866. That's the law report. Now the question is this.
Before even Nigeria was amalgamated.
And of course, there are many. Those of 15-something are still in existence. The question is this.
Well, what bearing does it have to our elections?
Saying. From all this year, today, decisions are still being taken. Even though life does not drastically change, but from all these years till to date, us are still sitting taking decisions. Why? Because each fact is on its own. Each fact is on its own. The fact, APM presented a peculiar fact that couldn't happen until now. This is of INEC, PDP, and INEC. Because PDP and INEC has a different stream of stream it was running. Ours was running a different stream. We came in on the basis of a constitutional provision that election can be questioned on the issue of was the candidate validly elected? If there will be no locus, are you now saying it means then that once somebody is elected, then there will be no way to contest that election? Ours was just to think up the question of whether under Section 142 there was a valid nomination of a vice presidential candidate. And if there was no valid nomination of a vice presidential, was there a presidential? It's a razor differentiation, but it has a very vital role to play, because rule of law means every tiny of the law has to be looked into. Every tiny of aspect that governs the society has to come in within the compartment of that rule of law. It's our case. That's the case with
it. Okay. What I get from what it is that you have argued is that, because you said that this is not about double nomination. This is not about double nomination, even though it looks like it, but you say it's not about it. What you seem to be contesting, and then let me just get my own, and you can say that's not what it is that what you were essentially contesting is that the withdrawal and the nomination of Vice President Kashim Shettima as a candidate did not happen within 14 days.
Yes.
That's essentially what you were contesting.
That's our case.
Do you have evidence to that?
Evidence?
Yes. You have evidence as to when his name was withdrawn, and you also had evidence as to when,
Yes, it is all before the INEC.
Okay.
The Masri withdrew.
Okay.
As stipulated by Section 33. Mm-hmm. But the same 33 said you have to renominate. You have to, the candidate has to be substituted within 14 days. Mm. But then, if you look at the dates of removal, when he left and when Shettima came in, the 14 days wasn't there.
So we think that this matter could come up again in the future?
I think it will certainly.
All right.
Because it has a lot of importance in our constitutional development. It has.
All right. Well, I have to thank you for coming on. Mr. Chukwuma Chukwume is a senior advocate of Nigeria, the lead counsel to APM, and also former Attorney General and Commissioner for Justice for Imo State. We will be back in a moment. Don't go away.